I think we'll get started. Good morning, everyone. I'm Ann Wolf, the Education Events Director for the Contra Costa Bar Association. I want to welcome you to the Real Estate Section's regular Friday program, monthly program. The ins and outs of real property liens and encumbrances will be the discussion points today. And the speakers have asked that you put your questions in the chat, and they will be looking there to respond to those. I also want to let you know your attendance certificates and materials will be sent out later within a day or so. And so you should look for those in your email. If you're a member, the certificates will show up in a day or so in your My Events tab in your member profiles. So I'd like to get started and introduce our speakers today. First, we have Cary McReynolds, who is a current member of the CCCBA bar. He's a board of directors. And he has over 24 years of experience, and he's earned a reputation as a strong client advocate who is professional, ethical, and knowledgeable. His practice areas focus is on civil litigation, real estate, and construction. I also would like to introduce Sean Ponist, and he is the founder of the Ponist Law Group, a firm specializing in real estate, construction, defect, and business litigation. Prior to founding his own firm, Mr. Ponist was a prosecutor with the Marin County District Attorney's Office and in-house counsel for Marcus and Millichamp Real Estate Investment Brokerage Company. He has successfully tried over 30 cases to verdict. And for the past 10 years, Mr. Ponist has been, among other things, recognized as a super lawyer and has been a fellow of the Litigation Council of America, a trial lawyer honorary society whose membership is limited to less than 0.5% of North American lawyers, judges, and scholars. We're happy to have both of them here today. I'm going to turn it over to Sean.
Thank you, Ann. And thank you, everybody, for coming out. I know last night with the Giants-Dodgers game was a brutal one, and many people are mourning, so I do appreciate you guys still coming out and coming to this presentation. Just a quick word or two before we jump into the materials. We have a lot of material that we're going to get through, a lot of information about different types of liens and encumbrances. And many of these could just be topics all of their own. For instance, mechanics liens could be a whole day's topic, and there's, in fact, whole treatises just set aside for mechanics liens. But we're going to basically be giving you an overview at 10,000 feet so that the next time that you have a case that touches on something, at least you'll be able to kind of have your feet wet and have a start or a launching place to go from. Related to that too, there's only so much we can get into in this presentation in this 1 hour. However, the syllabus we did try to make a little bit more, and it is in fact much more robust. So a lot of the technical details you will find there that we may not actually drill down into right now when we're doing our presentation. So with that said, let's jump into it. And Cary, why don't you start us off with a discussion of Lis Pendens?
Good afternoon. So if you look at your syllabus, I'm going to essentially parallel that and just keying off of what Sean said. The way our syllabus is laid out is we try to provide statutory and practice guide sites. It's to give you an outline and a toehold, and you can use it as a guide to get further information as you need it. Lis Pendens, I'm sure everybody is relatively familiar with, but it is a notice to third parties that there is an action affecting a piece of real property. And some people get confused thinking that it prevents transfers of real property or somehow otherwise encumbrances the property. It does not. It just puts the world on notice. Practically speaking, a Lis Pendens will tend to stop refinances of the property and sales because for some reason people don't want to buy property subject to them. If you have an action and real property is at issue, generally it'll be an issue of title or a transfer or whether somebody has an inheritance right to it. You can file a Lis Pendens when you file the action. The claim of Lis Pendens must be apparent from the face of the pleadings. Otherwise, it will be subject to the expungement. So if it appears there's a claim, make sure that you have stated a real property interest right in the pleadings of the complaint. Procedurally speaking, the way that a lis pendens is normally done is you file the action and then you turn around and you are going to take the lis pendens that you have also requested, and you are going to mail that notice on your way to the recorder's office. So you literally walk out of the courthouse or have your runner walk out of the courthouse, pre-made envelopes, and send a file stamp copy of the lis pendens to them. You then go to the recorder's office and you record that notice. And then after that, you go back over to the courthouse and you file a copy of the recorded lis pendens, which you then serve on the parties. You want to do this as close to the beginning of the action as possible, because this is one of those issues where first in time is first in line. So the sooner you have a lis pendens on file, the more protected you are against subsequent parties that may come in and file their own, subsequent lien holders, subsequent judgments. Once the lis pendens is filed, it's automatically on title and remains until either it's withdrawn, expunged, or a judgment is entered. There is no time limit on that. If a party wants to do an expungement, they have to file a motion to have the expungement granted. The expungement is based on the fact that it doesn't in fact involve real property, that there's not a probable validity that the real property claim will occur or be proven by a preponderance of the evidence, or adequate relief is available by giving a bond or an undertaking. Expungements are granted liberally if the judge feels that there is adequate security or that there can be a bond posted. That seems to be the most common one. Just an important thing to note with expungements is, unlike most areas, there is fee shifting and right for attorney's fees on an expungement. So if you file and you request one and you prevail, you can get the fees. Likewise, if you oppose one and prevail, you can get the fees. Keeping in mind that just like with discovery motions, judges have a great deal of discretion, so it is going to depend on your individual judge whether they will or will not award fees. The expungement is not effective until it's recorded, and it cannot be recorded until after the period for writ of mandate can be brought on the order of expungement. So there is a lag in there in time. If you have a client and you need to expunge, make sure to factor that in. For example, if they're trying to do a refinance, let them know you're going to need an extra 30, 60 days to get everything done. Moving on quickly to expungement liens, or prejudgment and attachment liens. Prejudgment attachment liens are a subsection of attachment liens, which is a practice area unto itself. There's an entire area of attachment, and it is very procedurally driven. So I always recommend, if you're going to try to do an attachment, go through, read the practice guide, follow the steps, and they're a pain in the rear. That's the only way to put them. There are a lot of steps. My experience has been that judges vary greatly on their willingness to grant attachments. Some are more than willing to do so. I have had judges where it is completely warranted. We meet all the factors and they say, that seems like a little bit of a strong remedy. I'm not going to do it. So it really seems to be governed by the individual judge's beliefs. In order to attach real property, so this is essentially on top of your request for attachment and your writ of attachment order, you need to show that the party who you're seeking to attach against has an interest in a real property. That interest can be an ownership. It can be a long-term lease of over a year. It can be a contingent interest. For example, they are a subsequent beneficiary. If they have a life estate, you can attach that interest. Be careful of the homestead exemption. The homestead exemption is applied very liberally in attachment matters. The party that you are seeking to attach against, if it is their residence, can assert the homestead exemption at any time before, after the writ of attachment, even post-judgment. So one thing to look at before you start doing it is there real equity in the property? The homestead exemption has gone up significantly in the last couple of years. I believe it is now a minimum of $300,000, and if I remember correctly, up to $600,000 based on the median price of sales in the county. In most counties in the Bay Area, that means there's going to be a $600,000 exemption. So the property, if you're going to do it, needs to have some real significant equity on top of the existing loans that may exist. Important tripping point number 2, if there is already security that has been provided by the party you're seeking to attach against, you cannot get attachment against real property. The exception is if the security you have has gone down in value and you're no longer adequately secured, now you can seek a writ of attachment or a right to attach against a piece of property. The important note is that seeking the attachment does not violate the one action rule. So if you needed to do a judicial foreclosure later on, you are not precluded from doing so. Finally, on obtaining the, if you file a mechanics lien does not affect your right to seek a writ of attachment. They are 2 separate remedies that overlap slightly. I'm not going to go through the procedural steps. We've listed them out. This is driven to a large extent by judicial counsel forms. I highly recommend that you use them where possible because the judges reviewing them are familiar with those forms. It makes it faster and more efficient for them to go ahead and go through it. And hopefully more likely that if you're seeking one, it is granted. If you are opposing it, that you can point out why it should be not granted. The attachment lien is good for 3 years. It is important to calendar that because, as we know, getting to trial takes a while nowadays. And many cases are taking longer than 3 days or 3 years. The issue arises that you need to do a motion according to the statute between 10 and 60 days prior to the expiration of the attachment lien. And within that 10 to 60 day window, you also need to get the signed extension and record it prior to the expiration date. So you're not only seeking the relief and trying to get your hearing, but a signed order that allows you to get it recorded. And those are good for 1 year. So every year you have to go back after the 3rd year. So I recommend that it be calendared for that 60 days, and you're probably going to have an order to shorten time ready to go because motions seem to be set out 3 to 4 months. Or you may motion to advance, alternatively to order to shorten time. The removal of attachment lien is pretty straightforward. It can be obviously removed by the party who sought it or upon a court order, which is done if the party has sought release of it. The really important part is if you're representing a defendant, the court is supposed to put in their judgment, if the defendant prevails, that the attachment is discharged. So if you're representing a defendant in the action and you prevail, make sure the court puts in the statutory language that's set forth under D there. That's kind of your 10,000-foot overview of the attachments. I'm going to turn this over to Sean on the HOA liens.
Thank you, Cary. And right before we get there to the HOA liens, just touching on what Cary said too, the attachment liens are an extreme remedy that courts sometimes are willing to grant, many times are very reluctant, because essentially you're getting the relief that you wanted. If you succeeded after trial, after judgment, you're getting that lien and you're getting that up front. So to that end, if you're going to go through this process, you really need to make sure that your papers are really solid, perhaps even be prepared to call in witnesses. And if you're going to go to this length, it's really important as well to be I think to make sure that there's really something there that's worth attaching. So get an investigator, see what the assets are, both in terms of the real property assets, running a title search, but also if there may be some accounts or anything else there. And with that said, let's jump on over to the HOA liens. And I think everybody pretty much knows what an HOA is. If you live in a condominium, townhome, a planned development of any sort in single family residence, you're going to have an HOA. The HOA is able to impose monthly fees. They're able to impose special assessments. And if you don't pay those as the homeowner timely within 15 days under the statute, unless there's a different provision, a different period of time that's longer under the CC&Rs, then you're delinquent. And if you're delinquent, then the HOA can take action, including an HOA lien. And an HOA is entitled to, when it does its assessment and trying to get the delinquent fees, not only the amount that has not been paid, but additionally attorney's fees and costs, additionally interest, and additionally late charges as well. So a lot of times what starts off as a relatively small amount that could be owed, once you get the attorney's fees, late charges, interest, and all that stuff compounded in there, it gets a little bit bigger and maybe much bigger. There are some limits on when an HOA can file a lien. One of them is that the amount in dispute needs to be at least $1,800 or more, or the amount that's outstanding and hasn't been paid needs to be outstanding and unpaid for more than 12 months. And I know what you're probably thinking, like, who would ever, if you had an amount that was less than $1,800, go through where you're going to hear about all these steps to impose an HOA lien and do anything? It happens, and we're going to talk about one of those cases. But putting that aside, typically the more reasonable approach for an HOA when there is an issue where a homeowner has not made payment is just simply to go to small claims court and pursue it that way, rather than go through all the steps that I'm about to tell you about. So the first thing that an HOA needs to do before it can even begin this process of actually putting the lien on the property is to provide proper notice to the homeowner. And proper notice isn't just, hey, you owe us some money. If you don't pay, we're going to lien your property. There's a bunch of notice requirements. One, the notice must provide a general description of the collection and lien enforcement procedures of the HOA. Two, the method of calculation of the amount that's owed needs to be set forth. Three, there needs to be a statement that the owner that's delinquent has a right to inspect the HOA records to see about this amount and verify this amount. Fourth, there's something that needs to be put in 14-point lettering, all caps and bolded, that it says, important notice. If your separate interest is placed in foreclosure because you're behind in your assessments, it may be sold without court action. So those are the main things that need to be there. What else also needs to be in the notice is there needs to be an itemized statement of the charges. There needs to be a statement that the owner is not going to be liable for the charges if the owner can show that the owner has already paid the charges. There also needs to be a statement that the owner is entitled to have a meeting with the HOA board of directors. That the owner, there's another statement advisement that's needed, and that's that they have the right to dispute it, and they can go through a meet and confer program with the HOA to do so. And the last thing is that they also have the right to alternative dispute resolution to try to resolve this. So the notice is very important. There's all these statutory requirements, and the HOA needs to satisfy all of them. Let's say they go through all that. Maybe the owner ignores it, or maybe they go through these meet and confers and the ADR process and all the rest of that, but there's still no resolution, still no payment. At that point, the HOA on the second step can then take action to file a lien. And what they need to do first is hold an open board meeting, have a vote by the majority of the board members that the lien should be placed, and then record in the minutes that decision that the lien can be placed on the property. So that's the second step. The third step then is actually recording the lien and then providing notice to the homeowner. And the notice needs to be provided within 10 days for it to work. And so there's a couple cases I'm just gonna run through real quickly that are sort of fun cases, I guess, from a perspective of how ridiculous things can be. I mentioned earlier the fact that, who would ever pursue a matter when we're only talking about such a trivial amount? Well, it does happen. In the case of Masurey versus Epstein, Grinnell, and Howe, and this is in the materials for the full site, there was basically a dispute over about $385 that went all the way up to the Ninth Circuit. They said the homeowner owed $385, and the collection attempts were made by the law firm of Epstein, Grinnell, and Howe. And this is sort of a cautionary tale for all of us that if you're trying to enforce a security instrument, then you are doing attorney work and you're protected and you're not a debt collector. But when you're actually trying to collect the debt, even if you're also trying to enforce a security interest, then you are a debt collector if it deals with family, household, or other personal objectives. And here, HOA fees, the court said that's clearly household type issues. So the big mistake here, according to the court, was that the language, and it didn't follow exactly the language that we've been talking about that the statute requires, but basically said that if you do not pay, a lien will be recorded. If there's a failure to pay, so that will be recorded. It doesn't talk about all these other steps or anything else like that you have the opportunity to challenge. And essentially the court said you don't lay out the procedures, you're just doing a debt collection, and found them to be essentially debt collectors who violated the Fair Debt Collection Practices Act. So an interesting case, and you got to be careful when you are trying to collect. Another case I wanted to discuss briefly was the Diamond versus Superior Court of Santa Clara County Casa de Valle Homeowners Association. And in this case, there was a more significant amount of money that was at issue. There were some roof repairs that had to be done, and for the whole HOA, and there was about $14,000, and they did a special assessment. The homeowner thought that she had worked out a deal with the HOA on a payment plan because she didn't have $14,000 to just simply pay. Apparently there was some type of miscommunication, and the HOA just went forward after their meeting for a process and ended up recording a lien. Of note, there was two things that were not done as required by the statute. The first was the HOA failed to send her that copy of the recorded lien within 10 days after it had been recorded. The second is they failed to record in an open session of the board the fact that they approved taking action. As to the first point, the HOA responded, hey, look, we didn't send the notice within 10 days, but what's the big deal? She was out of the country anyways, who cares? As to the second point, with their failure to record it in the meeting minutes in an open session, they said, again, what difference does it make? She knew about all this action. Who cares if it got recorded in those meeting minutes? We all were on board. Everybody knew what was going to happen. And the court said, not so fast. When you're dealing with this, you cannot do just substantial compliance. It needs to be strict compliance. And because you did not follow those technicalities, that HOA lien needed to be expunged and removed. So that is HOA liens. And now I'm going to move into different types of liens and encumbrances that come about in connection with purchasing property. And a sort of an unusual one that we do not see a lot of these days, but I wanted to just bring to your attention so you could keep it in mind, is something called a buyer lien. And a buyer lien essentially comes into effect when you have an installment sale contract and the buyer has been making payments over a period of time, and then the buyer typically this is how it comes down. I discover some type of fraud, misrepresentation, and now wants to get out of the deal and wants to do rescission. So the buyer would have a remedy there for rescission. One of the remedies the buyer can additionally do, though, is file this buyer's lien and say, look, I not only should get my money back, but also I should be able to make sure that I get my money back by having a lien placed on the property so that I can get my money back, any taxes I paid, any consequential damages, and have that lien until my money judgment is satisfied. And the nice advantage of a buyer lien is that it dates back into the date that the installment sales contract was entered into. So certainly the buyer could go about and record a Lis Pendens, could take some, do an attachment lien, take other type of action early on when they file the lawsuit. But if we had a long installment period, installment contract where we're talking maybe 5 years of payments going back, the buyer may be able to go back even further and get a lien this way. So that's kind of the unique advantage of the buyer lien. One of the things to keep in mind is if a party is in an installment sales contract situation where there's going to be this period of time, although it's typically not done, it would make sense to record the installment sales contract or record a memorandum regarding that. And that way you could avoid some of those issues right from the get-go if you recorded that. So the typical scenario, and this is kind of an old case because we don't see the buyer liens being used that often, and typically we don't see installment sales contracts that often, but there's a decision, Montgomery versus Myerston, California Supreme Court back in 1921, 100 years ago. And there was an installment sales contract to buy a house for $7,630. The buyer was making a series of installment sales contracts and then learned that part of the information that the buyer was relying on in the purchase was that the house cost $5,000 to construct, learned that it was only $4,100 to construct, and felt that she had gotten therefore defrauded, moved for rescission, and also was able to get a buyer's lien going back to when she entered into that installment sales contract. So something to keep in mind. I think it's going to be a unique situation when you can employ it, but it could be a powerful tool under that situation. The next thing is deeds of trust, and I think we all know deeds of trust fairly well. So I won't spend too much time on it, but essentially you got three parties. You got the trustor, who's the borrower. You've got the beneficiary, who's effectively the lender, and you've got the trustee, who basically oversees the actions if there's going to be any enforcement that's necessary on the deed of trust. And in California, we commonly use the language of a mortgage. I got a mortgage, she got a mortgage, I'm paying this on my mortgage, but we really don't have mortgages. It's truly a promissory note and deed of trust, and this is what we've got. One note I did want to make on deeds of trust, and I've had a case or two like this where somebody says that the trustee who did the foreclosure sale breached their fiduciary duty. And we kind of know that concept, right, of a trustee. Don't trustees have fiduciary duties? But they really don't in the context of a foreclosure trustee in this situation. Their goal and their objectives are strictly limited to what's in the statute. And really, there's case law to this, unless there is actual malice on the part of the foreclosure trustee, they don't have a liability. So unless they're really just trying to intentionally go out of their way to hurt the borrower in some sort of unwarranted bad way beyond just trying to get their property sold, they're not going to have liability, even if they make mistakes, errors, or the like. The other thing that I want to talk about in connection with the purchase of real property is the issue of options to purchase. So a moment ago, we were talking about installment sales contracts, and typically those do not get recorded, but typically in the context of an option to purchase, the option contract or a memorandum of the option contract is going to get recorded. And that puts the world on notice that we have an interest in this property, we have the right to buy it, and this property just cannot be transferred. And so, and in doing that, one of the things that you need to consider is whether you want to record the entire option to purchase or whether you want to record just a memorandum of it, because not all the option terms need to be put in there. You don't have to put in and provide the world notice of the purchase price, for instance, so you can keep that separate if you don't do that. So those are some of the liens that are associated with instances when somebody's trying to buy property and issues come up. And with that, why don't I turn it back over to you, Cary, on mechanics liens.
Thank you. Mechanics liens, again, are one of those practice areas that are in and of themselves. Before going through the general outline, the big thing I always see with mechanics liens with clients and potential clients is they call and say, oh, I have a mechanics lien and I haven't been paid. And the first question is, when did you file it? Followed by, when was the project done? Most of the time, it seems that you get the call about 6 months or a year after everything is done, when the mechanics lien is no longer valid. So I always caution people, look for those gatekeeping issues if you have a client that's asking you about them before proceeding too far down the path. So a mechanics lien, like these others, is a potential encumbrance against real property. It can only be filed against real real property, not against public works projects. If you have a client with a public work project and they haven't been paid by the prime contractor, the remedy is to file a stop payment notice. Stop payment notices and public works is a whole subject unto itself, but just be aware of that. Similarly, if it is a large private project, be aware that there are likely bonds on the project that your client can proceed against to get funds if they have not been paid. So there's an explicit list of who can get a mechanics lien: direct contractors, subcontractors, material suppliers, equipment lessors, laborers, and design professionals. And it is essentially anyone who works on the project. It's important that you note the distinction between design professionals and the others, because their time to file is slightly different, as well as the preliminary notice requirements. So before any mechanics lien can be filed, the general default rule is preliminary notice has to be given, and that is sent to the owner, prime contractor, and lender if you know who the lender is, or if there is in fact a lender. The way to remember who needs to give preliminary notice is that it applies to anyone that's not in a direct contractual relationship with the owner. So subcontractors, material suppliers, people who rent equipment. The one exception to that direct contract requirement is a laborer. And the reason is the state wanted to make sure that laborers, if they're not getting paid, have a right to recover, and recognize that most laborers would never file a preliminary notice, wouldn't even know they needed to. So there's an exception drawn out for that. Preliminary notice is supposed to be filed within 20 days of commencing work. And that commencement of work is specific as to the person who is filing the notice. So if you're the foundation guy, you should be filing it within 20 days of starting your work. If you're the trim guy doing the finish at the end, or I should say trim person, because there are people that are other than guys doing it, and quite a few. But if you're the trim person, you may be the last person coming in to do work on the job, and your filing needs to be within 20 days of you starting that work. If the 20 days is missed, it can still be filed. the issue is that the preliminary notice will only relate back to 20 days before its filing for securing any payment. So once that preliminary notice is filed, if you need one, or if you don't need one, the next step is the actual mechanics lien. Mechanics lien has to be filed within 90 days of completion of the work or 60 days of a notice of completion or ceasing of work if you're the direct contractor. If you are someone else, it has to be done within the 90 days of the completion of the work of improvement or 30 days after a notice of completion or cessation occurs. So you get into this issue of what is completion, and the code fortunately defines it. It is really important to watch if you have a project that has work stoppages. What often happens is funding runs out or gets dry and all work stops on the project. And if it stops for more than 60 days, that time to file a mechanics lien has started. Even if they restart later, you cannot go back before that date. It is a factual argument at trial, but it creates all kinds of problems. So be aware of that. Also, what we're seeing in a lot of projects nowadays is where there's not just a single prime, but the owner / developer may be acting as, in fact, the general contractor or the de facto general and directly hiring the direct contractors. So what used to be subs are now direct contractors. There is a little loophole in there where the direct contractor, each one is treated as its own individual project for time requirements for filing these completions, mechanics liens within completing work. So you could have, for example, the person that does the grading work way at the beginning of the project, in fact, needs to file their lien within 30 or 90 days or 60 days of their completion, depending on what has been recorded and what sign-offs have occurred. So for the preliminary notices, by the way, most forms, mechanics liens forms and everything else are available through the CLSB. You don't have to reinvent the wheel. They update them regularly. They're free. So I always recommend start with their forms because they're easy to use and they comply with the code requirements. The one form that isn't historically there is the preliminary notice. Most of you are probably aware of this, but Sacramento County Public Law Library has a treasure trove of information on all kinds of things, and they do have a good preliminary notice form. I'm not going to go through the steps for the giving the notice. It's listed out there, as well as what to file for the mechanics lien. I will tell you that the other big issue besides not bringing a timely mechanics lien is failing to timely foreclose on the lien. And this pops up time and time again. It must be done within 90 days of the filing of the lien, or you're done. The lien is avoidable. It can be expunged. The party cannot proceed on a foreclosure of mechanics lien. There is no tolling for it. The only exception is an extension of credit, which must be in writing and must be recorded. I have never actually seen one done in 20-something years. So that is the other one that I see people trip up on all the time. A lot of calls that I've gotten on it is when a expungement is brought for the lien to remove it. Usually it is a contractor calling saying, I got this nasty letter from an attorney demanding I remove my mechanics lien and they owe me money and I'm not going to do it. Well, you have to explain to that person that if the lien has expired and they don't voluntarily remove it, a petition can be filed by the party who's affected by the lien. It will be granted by the court unless something miraculous happens that the court doesn't. and they're entitled to their attorney's fees, reasonable fees, but still their attorney's fees on the expungement of the lien. It used to be that there was a set fee and it was something like $700 or $1,500. It has since been raised to reasonable fees. So between the sending the letter and everything else, the person who holds the improper lien could end up $4,000 or $5,000 owed for a lien that they have when they're in fact owed money. If you do actually bring an action to foreclose the mechanics lien, a Lis Pendens is mandatory and must be filed within 20 days of the filing of the action to foreclose. So always make sure that you put on your checklist to bring a Lis Pendens if you foreclose. I always tell people the important part with mechanics liens is, while they're a good tool and they can really help if there's a construction lender on the project and the person and the owner of the property needs to refi out that construction loan, it's not the end of the world if a mechanics lien is not timely filed, timely foreclosed, because all the other contractual as well as other basis for claims such as quantum merit still remain. So if the mechanics lien deadline is missed, for the client, you still go forward, you file your action, and you just proceed on the remaining causes. One thing to watch out for is notices of non-responsibility. You'll generally see this in improvements to leasehold interest where it's owned by a large property owner. So strip malls, office buildings, the owner will post non-responsibility. And if they comply with the requirements, that means that the owner is not liable for the mechanics lien. Now, you could still technically lien the leasehold interest, but I've never seen a leasehold interest actually foreclosed, so I don't know what you get out of it. Liens all relate back to the same date, so there is no separate priority. If in fact a foreclosure occurs, people get paid in proportion to their lien interest, not based on first in time, first in right. I always tell people when dealing with contractors, check the license bond. You might be able to recover against it. It's not a lot of money, but there's a $15,000 license bond at a minimum. It's a little bit larger for the pool guys, and you may be able to get it. One tripping hazard are design professional liens. And design professional liens are liens brought by, for example, architects, and they occur for work provided to the property before actual construction occurs. The issue is that the design professional files that lien, and then when construction starts, they now have to file a mechanics lien because their design professional lien expires. So if you have an architect client or someone else, surveyor, landscape architect, engineer that's done work, keep that in mind. Make sure you're aware that you must convert their design professional lien into a mechanics lien to maintain it being valid. And stop payments I addressed up above, that they apply to public works projects. Again, both public and private, large private projects will usually have bonds that are required to be posted by the prime contractor. Always look for those in the prime contract because that is a good source of getting clients paid if you represent a subcontractor. Going to go back to Sean for the judgment liens, and then I'll cover the very short section on bankruptcy.
Thank you, Cary. Before we do, I wanted to follow up on something that you mentioned a moment ago with respect to mechanics liens, and that was that you need to have the foreclosure action to foreclose on mechanics lien within 90 days. You mentioned unless there's an extension of credit. Can you please explain what that is?
So if the parties agree to either do further work or my understanding is enter into a credit letter where they say you owe X dollars, I will finance that for X period of time. So example, there's $10,000 owed. We agree that we will finance it for 60 days or 90 days, that you can then record that. Again, I have never actually seen it done. So it's more theoretical as far as I know than something that actually occurs.
All right, thank you. All right. Before we get into bankruptcy, we're going to talk about judgment liens, which is a very powerful tool. Most of the liens that we've been talking about today are specific liens. So a specific lien would attach to a specific property, but a judgment lien is a general lien. So that's going to attach to effectively any property that the judgment debtor has. So it's a very powerful tool. And one of the other powerful features of it is that it attaches not only to the property that the judgment debtor currently has, but any property that the judgment debtor acquires in the future, this lien will attach to. So typically, how it is affected is through an abstract of judgment that gets recorded at the county recorder's office. Another advantage of this is it's cannot be expunged. So I mean, as long as it's a valid judgment that you've got and you valid abstract and you record it, the only way that it's going to come off is once it gets satisfied or if it's voluntarily released. So if somebody is a judgment debtor and they own community property, that and you record the abstracted judgment, the judgment lien is going to attach to the entirety of that community property. It's going to be that whole piece of property. However, if the person holds title as a joint tenancy or a tenancy in common and they get a judgment against them and you go through this process and you perfect the judgment lien, that will only be against that judgment debtor's interest, not the entirety of the property. So I mentioned just in terms of the steps that you would need to do. First, of course, you got to get your judgment. After that, you get an abstracted judgment. And the form is in the Judicial Council forms. It's use of abstract judgments, civil and small claims, e.g. 001. You complete that, and then you get that recorded with the county recorder's office, and you're basically good to go. A quick note or two on that subject. If somebody's got a judgment from another state, Massachusetts, wherever, they cannot just come into California and take an abstracted judgment and try to record it with the county recorder's office. They're going to need to go first and get that out-of-state judgment recognized as a sister state judgment here in California, then get an abstracted judgment and move forward with it. The other thing too is, and I mentioned this before about using a private investigator, I think here it's just as important as anything else to do a title search, use a private investigator and see all the areas and locations where somebody holds property. And depending on the amount of the judgment, you may want to use this as broadly as possible. So if you know somebody lives in San Francisco and works down in San Mateo County, you probably want to record both those places, but you might want to be recording in Contra Costa, Alameda, the whole area around there, just so you really saturate in case the person decides to buy some property in their neighboring county. And then the other tip is just to, after you get this recorded, to actually do a title search and make sure that it comes up. If it doesn't come up, it's not going to do any good, because at the end of the day, anybody else who acquires a property thereafter, as long as they're a bona fide purchaser for value, isn't going to have notice, and they'll take a clean and clear of any sort of judgment interest that you got. So how long does the judgment lien last? It effectively lasts for 10 years. And then if you need it to last longer, you can go into court and you can get the judgment extended, file an application for renewal. And that's under CCP 638.120. So kind of summing up, the power of this is you're going to be able to broadly be able to put this lien on any property that they have just by filing a single notice. You don't have to specify, know exactly which property it is, and you don't have to state exactly which property it is. It's going to apply to later acquired property. So if the judgment debtor buys some property and not just trying to squirrel away, whatever money that they do have because they know about this. That can be powerful. And also, it's important to keep in mind that this will relate back to what we were talking about before. It will relate back to the time of the Lis Pendens, and will relate back in terms of priority to the time of any sort of attachment lien. So those are judgment liens. And Cary, why don't you tell us a little bit about the bankruptcy part?
Okay. I was actually contacted by Karina Beljeski, who is, I believe, a member of the bankruptcy section, and I think probably the real estate section, who saw that we were doing this presentation and said, "Hey, can I send you some info on bankruptcy?" And I said, "Sure." So we've put this in here. I know a little about bankruptcy. I clerked for a bankruptcy judge a lot of years ago. So I am relatively familiar with the bankruptcy system, but have forgotten a lot too. So this is going to be very global and general. The important thing, I think it's pretty much everybody knows, is if you have a client that has a lien or a judgment and receive a notice of bankruptcy, always assume that the Section 362 automatic stay is in effect. And the automatic stay says you cannot enforce anything, you cannot proceed with a current action, you can do nothing to further your state action or collection efforts unless the bankruptcy court gives you permission. There are exceptions to the stay, but I always recommend assume the stay is in effect unless you are aware of a specific exemption, or you have gone and gotten applied for a motion for relief from stay with the bankruptcy court and it has been granted. The specific lien issues here would apply if you have liens or judgments. Keep in mind that the exemption limits in bankruptcy and individual bankruptcies can be either set by the bankruptcy rules or by the state limits. So as far as I know, and don't hold me to this, but if you have a judgment lien against a real property, the higher new homestead exemption limits will apply in bankruptcy. So just be aware of that. Again, this is just issue spotting, so you don't inadvertently get in trouble with the bankruptcy court. If it gets more detailed, you need to look at it or bring in bankruptcy counsel that regularly practices in the area and can tell you off the top of their head or with very little work of whether you need to be worried and what steps you should take. The one other thing I would say is, as soon as the notice is received, find out when the creditors meeting is occurring and when the plan confirmation meeting is occurring. Those are very important dates because they trigger objection timelines. That's my very quick summary of bankruptcy.
Thank you, Cary. We're putting up our emails here, so if you have any questions after this presentation, feel free. Cary and I welcome any questions to shoot us an email. And likewise, if you have any questions right now, feel free to put it into the chat or the Q&A. Well, thank you for that, Malcolm. We appreciate it. We'll just give it maybe like another 15 seconds here, but otherwise, we really appreciate everybody coming out, and thank you for your time.
Thank you, and thanks. And hopefully this is helpful and a useful guide for the future if needed.
Thank you, Gary. Thank you, Sean. And oh, something in the Q&A popped up. What do we got? Any insight on so-called equitable lien claims?
I guess my question is, can you be a little more specific? I might, off the top of my head, generally liens are explicit and subject to strict statutory requirements. And so I think an assertion of some type of equitable lien would have to be very fact-driven and require pretty good analysis.
Co-owners of property, it says.
So there you get de facto liens if you are co-owners of property. And for example, let's say your tenants in common and one tenant pays the fees on the property, let's say taxes, and the other tenant does not. And again, this is a big assumption, assuming that both are in possession of the property, not just one of them has possession of the property, they can assert an equitable lien against the other. They are entitled to contribution for the share in accordance to proportionate ownership interests. The issue is both of them are untitled. Neither can sell without the other's permission. So there's nothing to file because they already have the right to not sign anything to sell the property and keep it encumbered. They have to bring an action in court to assert those rights and the right for the reimbursement. So it's, while they technically have a equitable lien against the other person, it still has to be, the remedy is to file an action for contribution.
Ann, I think you're on mute.
I am. Like in a partition action, including claim for contribution, wondering whether co-owners are required to record anything for any equitable lien claim.
I think Cary pretty much answered that. I think when you're dealing with an equitable interest, and that would lead to the equitable lien claim, that it's really something that needs to be decided by the court before you can record that. I see that there was a question, Ann, about can I get a recorded copy? I missed the first 20 minutes.
To contact me separately. This is recorded and it will show up in our self-study at some point. There's also a question about an issue with valid deed of trust. Come up. Oh, are you guys looking at the Q&A?
I am, but I'm seeing, or wait, I'm seeing chat. Maybe that's what I'm missing.
The Q&A.
Oh, there it is. Oh, I think Gina was responding to something. They also come up where there's an issue of valid deed of trust.
All right, everyone. Well, it's 1:01 and we're gonna send you off to a wonderful weekend. And now that we don't have baseball in our future, let's turn to some football. I'd like to say go Bears, but who knows what's going to happen against the Ducks tonight. So anyway, everyone have a great weekend. Thank you, Cary. Thank you, Sean.
Thank you.
Thank you. Thanks for having us.
We'll get all this information out to you as soon as I can. Thanks, everybody. Bye-bye.